Thanks, Jess. Hopefully most of you know me by now. I'm IP Counsellor posted here at the Australian Embassy in Beijing, where we are right now, for IP Australia. This is IP Australia's first and only overseas posted position. I've been here since December 2016, almost 3 years. My position in general terms is to help Australians protect their IP in China. So I do a lot of outreach and education work with businesses, SMEs and others, support on individual inquiries, and then also our government-to-government engagement and helping guide our China IP policy. The practical assistance side of things helps me identify things that need addressing at the policy issues. So if you do have issues, it's very useful to have information and feedback from Australian IP attorneys, so please do reach out. I give guidance on specific inquiries, but I of course don't give legal advice, and I always steer people towards Australian IP attorneys, lawyers or Chinese practitioners as appropriate. These webinars we've been doing this year have been trying to get some more detailed professional level assistance to Australian IP attorneys and lawyers. So I've been very glad to have guest speakers come in and present on their topics, and very glad to have Oliver Lutze join us today for one on patents. Now, Oliver is based here in Beijing, Spruson Ferguson's China manager, and he focuses on patent matters with a particular focus on the Chinese markets. Oliver has a load of experience that he'll be sharing. He's an expert in life sciences, pharmaceuticals and chemistry. He was senior patent counsel for over 15 years at Bayer, based in Shanghai, I believe, and led a Greater China IP team from Shanghai. His technical background is in chemistry. He's a qualified European patent attorney and German patent attorney as well. And he was also chair of the EU Chamber's IPR working group here in China. So very happy to pass to you now.
Yeah, thank you very much for the introduction, David. A very nice good morning from Beijing, or maybe during your lunchtime, a good day. I would like to present a little bit of my experience of 12 years in China, both in-house and with a firm. And we can have a look at the agenda, what I'm going to talk about today. So on the first part, I will give a little bit of an overview on the status of the China patent system, then introduce the 3 types of patents and their value in the Chinese system, talk about patentable subject matter, and then go through actual topics and issues that I deal with a lot with clients during the time that I work here in China, and which are still issues nowadays. So those are following in the following, and then in the end I will talk a little bit about the court system, the Beijing IP Court, and formality issues that exist, which are very important for clients. And if we have time for that, I will also give some insight into enforcement. This will be basic insights. So the main focus is on the first part, an overview about the system and the types of patents and issues people have. So if you look at the China system and the China environment, you will know, I guess, that there is a huge growth. So we still have double-digit growth rates. In 2018, again, patent applications are rising with double digits. There's a huge number of utility model patents also being filed and designs. It's cooling off a little bit in the first half of 2019, so that it was a little bit down, but still growth rates are very impressive. So re-examination requests are up 22%, invalidation requests are up 13%. So it's a huge growth there, and Chinese patents become more important for many of our clients. What is also important to note is that the quality of the patent office is good, I would say, and is improving. So complaint rates are falling. It's an advanced patent office, and there's mentoring of the examiners. So it's really in good shape. Of course, some of the examination standards are quite restrictive, but it's at least predictable, and therefore quality is good in that regard. Patent enforcement with all the patent filings increasing also increases. So for the administrative law enforcement, where numbers are available, there's also a more than 20% increase over the years. So patent filings in China are important. If you look at enforcement of patents, it's important to note that there are currently 2 tracks that you can use. One is the administrative track, which go through local offices of the patent office. So it will be a local patent office that does this enforcement. And then there's judicial track via the court system, civil lawsuits being filed. The left side, the administrative track, is not so popular for patent matters, the reason being that the local IPO cannot award damages, and very often the case is appealed anyway to the court system afterwards. So that has not been very useful for patents in the past, but that might change with the Fourth Amendment of the patent law, which will give much more rights to the local IPOs with regard to awarding damages and with regard to also do evidence preservation, which is a huge problem in China. So it can be expected that the importance of this part will rise, and I think it's an interesting development that we need to watch with the Fourth Amendment of the patent law. Already established have been new courts, which includes the Beijing, Shanghai, and Guangzhou IP courts. They have quite unique features, so each of them have different ones, and if you can tailor your infringement to getting the infringing product being bought in one of the jurisdictions of the court, you can utilize those. In the beginning, the Beijing IP Court was very fast, so the procedures were short. I think that's slowing down now, but it was a feature that was quite interesting for the first establishment of the court. Shanghai court very much pressures into mediation, so that might be of a benefit, as I will explain later on. So every court has specific features that can be utilized, but the most important point is that they have technical experts. So when you have a technology which is a little bit more complicated, it is very useful to utilize these courts, especially, for example, for biotech, because all other courts do not have technically trained judges. They don't have technical experts at hand, so these courts will then play an important role. That said, I also have to say that there are still good courts in other provinces. So if you have a chemical case, for example, Jiangsu province is an excellent place because the courts there are very used to chemical cases with a strong chemical industry. So you can play around with the courts, but Beijing, Shanghai, and Guangzhou IP Court are quite interesting to see with these new features that they're offering. Statistics on the civil court system are not readily available. I think the law firm of Rouse has a database on this, but also that one needs to be a continuous feed in and is not complete. So it's very difficult to get a hand on numbers there, but I think the patent litigation filings are also huge in China in that system with 2,500 cases per year, which is much more than in any other country of the world, although most of those cases are among local companies there. There are continuous efforts to improve the IP system in China, and I think the most important ones we have seen coming from the Beijing IP Court recently. They award higher damage awards. There are some cases where they really exceeded the normal standard that was there before in China, which was very low. So that is a positive development. They also help more with evidence preservation. That is also something which is a deficiency in the Chinese system, because in the past you always had to present all your evidence from your side, and the court was not really supportive in helping you to preserve evidence. So those are good developments that we have to see whether they continue. And then, as I mentioned before, there is a strengthening of the administrative litigation route planned in the Fourth Amendment of the patent law that might also help enforcement, because then it's a government authority that might help with evidence preservation. And in the Chinese system, government authorities are much stronger than the courts. So we can expect that if that is strengthened, that we see better opportunities to preserve evidence in China through that system. What we also see is that Chinese companies are pressured to put more efforts into doing quality filings. So all the subsidies for low quality filings are somewhat reduced. There is more of a focus to sponsor filings if there's quality, as has to be shown by foreign filings or grants. So that is an important development, especially for your clients, because I think freedom to operate opinions are gaining in importance, because the patent filings that we see nowadays are maybe the same amount, but there are more quality ones among them, so it's not all junk. So one has to be careful in freedom to operate with regard to filings of domestic Chinese companies more and more, and FTO becomes quite an important part of the work that we are doing here for clients in China. There are then a lot law initiatives to change the environment in China. I think the most interesting one for me, having worked in the pharmaceutical industry for a long time and linking to my early days lobbying activities, is the one in the pharmaceutical area, where we now look at copying the US system fully, so having a Hatch-Waxman-like system with an effective data protection, patent linkage, and patent term extension regime. That is all in the discussions. There have been policy announcements going that way. It has been slowing down a little bit recently, which is disappointing, but there are still discussions ongoing, which I know from my former colleagues at Bayer, that they are looking into this, and hopefully that system will be effective and newly established. Then there are changes in the guideline for examination, mostly related with regards to software inventions, so computer implemented inventions and business method related inventions. Those are very much driven by the Chinese national champions. If you look who's a big player in China, you will immediately probably mention Alibaba or Tencent. So these changes in the guidelines for examination have been a little bit tailor-made for them, and I will talk about those changes later on. There are three types of patents in China, as I mentioned before: invention, utility model, and design patents. Let's have a quick look at all of those. I think you're very familiar with the regular patents, the invention patents. What is special features in China is that there is a very restrictive divisional practice, and I will have a special slide on that one later on too, as well as for the restrictive amendment situation and the situation with regard to supplement data during prosecution. I will talk about those more in detail. What we found recently is that the examiners are much more open to interviews, mostly handled by calls to the examiner. That has become much more useful, and there are even drafts for the guideline of examination under discussion, which should encourage examiners to do these calls. And they are useful because often you can discuss how to get broader claims granted, or you can discuss how the examiner would feel about a supplementary data submission. So those kinds of things can be utilized to get patents granted broader or faster, depending on what the interest is. I really have to highlight the importance of re-examination procedures. The reversal rate of appeals to the courts later on is very low, and they really do not like to look into inventive step issues. So you really have to focus on re-examination procedures, be it in invalidations or be it in the normal prosecution in a one-party discussion with the patent office. You have to win your case in re-examination. The appeals to the courts should be the rare exception, also for the formality issues that exist in the court system, which I will talk about later. Invalidation considerations during prosecutions of regular patents are very important. In invalidation, it's very difficult to amend the claims. There's been recently a decision about amendment of Marcus claims, which I will talk about later on also. So it's very limited to make amendments of the claims during invalidation, and you need to have your claims in good shape during the normal prosecution of your case. What's also important is that the patent should be in good shape, because high revocation rates present themselves in invalidation. Usually they can be up to 60%. So if a patent is attacked, it's usually a huge threat. And what is quite surprising to me sometimes is that these high revocation rates of 50 to 60% are the same for utility models, which are not even examined. So that's a kind of strange feature, that an examined right has the same chances of being invalidated than a utility model which is not examined. The utility models have a term of 10 years. They are the small patents. Why are they important? I think they are important because they are very fast granted after preliminary examination, and therefore they are very easy to get. Another feature is that it can be used as an additional right where you need to have a fast enforcement opportunity. For that part, you just have to do it right. So you have to file a Chinese invention patent and a utility model patent at the same time if you want to enjoy a fast enforcement opportunity via utility model while still proceeding with the invention patent. So you can file those at the same time. There are double patenting issues in this. So if you go with the invention patent via the PCT way and file the utility model in parallel, that is not recommended because then it hits a double patenting issue. So it's better to file an invention patent and the utility model at the same time, where the examiner will help you to overcome the double patenting issues in that regard. What is also important to know is you can't branch off a utility model patent from an invention patent, like in other systems, like the German system, which is my home system, and where China copied a lot of laws from, but this does not exist in China. So you cannot branch off a utility model from an invention patent later. You need to file it at the initial phase. What is also good to know is that utility models have been widely kind of misused by Chinese companies because they have been filed to get subsidies. So there's a huge amount of utility models around. And that causes issues because utility models are covered by specific conditions under the laws, which foresee, for example, a lower requirement for inventive steps. So they're very difficult to invalidate. Actually, for invalidating them, you would have to have 2 references in the same search class as the utility model to try to have a successful attack on inventive step. And that is a huge limitation. So take these utility models very serious if you're presented with them, because they're very difficult to invalidate, although they are granted without substantive examination. If you have utility models yourself, I think an important feature there is that before you enforce them, you need to confirm their validity by getting a search done by the patent office. That is an important feature to know also. The design patents are also a quite interesting tool in China, coming from the fact that those are not of a technical nature, so they are much easier to enforce. A judge who does not have technical knowledge is much more likely to be quickly able to decide on an infringement with regards to design patent, because it does not require an in-depth technical evaluation. That is something which makes designs quite useful. So especially if people copy things from your clients, like brochure photos and things like that, if you haven't registered a copyright, enforcement can be very troublesome, but a design patent can help to stop activities there. So it's an important part in everybody's portfolio, and it's good to have in China. What is specific about the design patent system in China is that they need to have a brief explanation included besides the drawings or photographs. So that is important to know. You have to spend some time on it or leave it to your agent to draft a suitable explanation of the design. And what is currently a huge problem in China is that no partial designs are possible. So no dotted lines are allowed, only the whole product can be protected by a design. That might cause issues with your clients if they filed a partial design as a priority and later on you come to China with the whole product being the only way that you can cover it by a design patent. Graphical user interfaces are something that is also patentable in China, but see again the limitation that only a whole product can be patented as a GUI design. So that means the GUI has to be shown on a mobile phone or a hardware screen to be protected, and that causes issues in enforcement. Then coming to patentable subject matter, I think what is important to know there is that there are certain exclusions. The first one in Article 5 is often overlooked, but once your invention has been made infringing on Chinese laws, then the patent will be invalid. So be very careful with regard to genetic resources that have been used from China and go into the making of the invention. Or of course, what is important is if an invention is made in China, it has to undergo a confidentiality examination in China before it can be filed overseas. If you don't adhere to these Chinese laws, the patents can be invalidated. The other exclusions in Article 25 are, I guess, the usual ones for many patent systems, the most relevant being the exclusion of rules and methods for intellectual activities, which covers the business methods to some degree, and the diagnosis or treatment of diseases in the form of methods, which are excluded in the Chinese system and are often the area which clients need to have advice on. Now I want to talk a little bit about inventions which touch these areas. So one is the computer implemented inventions, and as I've said, there have been some changes to tailor those guidelines to give better protection, maybe driven by the big Chinese companies in that area. But for the software patents, the big change is that before the amendment, only specific types of claims were allowed. So process claims with means plus function form, an apparatus claim with functional modules. But after the amendment in the guidelines, other claim types are now available. So there is the computer program product, machine readable medium comprising, and so forth. So you can draft these claim types which give much better protection for software implemented inventions. That said, the rules for being able to patent software are very similar to Europe. So the software needs to be linked to technical effects achieved, and they need to solve a technical problem. So that remains the same, but more types of claims are allowable in that regard. Business methods are not excluded per se anymore. In the past, whenever examiner found there's an element of the business method in the claimed invention, he would immediately reject the application. Now, with the revised guidelines for examination, it's clarified that if the business method involves technical features that solve a technical problem, there could be a chance to patent them. So you have to look how you draft your patent application. It's not an exclusion per se anymore. I don't want to go into details, but it's now more open to get protection in that regard, while the business method per se are, of course, still excluded. For the diagnostic methods, I think it's important to know that you should try first to cover all products which are not methods, so kit and apparatus, even DNA molecules, biomarkers, they all can be claimed, of course, because they are not a method. For the methods, there have been interesting developments in the courts, in the Beijing IP Court, because one applicant redrafted a claim from a method claim to an apparatus claim, so saying an apparatus for doing a method. And the Beijing IP Court confirmed that this is a possible way of claiming such things. So, for example, if you have a computer involved into running a diagnostic method, you can claim a computer that does certain steps. So that is a way out to circumvent this claiming of diagnostic methods, which I think is quite interesting. Then a topic which I worked on in lobbying since I've been in China, which is the filing of supplementary data and the inventiveness of chemical compounds. Let's start with the general view on patenting of chemical compounds. I think the most important thing to know is that they always must present an unexpected use or effect over the prior art, and that needs to be a qualitative change or quantitative change. And that needs to be supported by data, like in many other jurisdictions also. The issue in China is that this data needs to be supported by data in the specification, and I will talk about that in the next slides. But if you have data in the specification, you can get all types of inventions related to compounds patented in China, so new formulations, polymorphs or salts, stereoisomers, dosage regimes, if they meet the standards for inventive step, can all be patented in China. But the issue is really data in those specifications. It all started in my early years. I was in China when there were huge issues with regard to insufficient disclosure, because there a lot of patents were attacked by strawmen, arguing that there is no supportive data in the specification, so no quantitative or qualitative data. And they relied on newer examination guidelines of 2006 and 2010, and there were a lot of patents around, pharmaceutical patents covering blockbuster inventions that did not have those data, and they were all at the brink of being revoked or were actually revoked because no data was there. So that was a huge issue which was taken up in lobbying. So Commissioner Kapos from the USPTO and others met with high-level people in the Chinese Patent Office. And under this big pressure of a different practice than in all the other IP5 offices, they made some concessions on this. And the first time in 2013, when there was a news briefing where they said post-filing experimental data can be considered to overcome an insufficient disclosure issue if the person ordinarily skilled in the art can deduct the effect that is supported by the data from the specification. And they also said that the new guidelines for examination should not be applied to the old cases. So that was a big achievement for using supplementary data for insufficient disclosure. And now we see more and more clients have success in supporting applications with supplementary data if the issue is on insufficient disclosure. Has it been gone away after this? No, there's still an issue with supplementary data submission because it now shifted to a different area, which is the use of supplementary data to prove an inventive step. And there the issues are still accumulating. A lot of people have issues with regard to that. On this slide, a few cases are mentioned where in the specification there was data, but not data on an effect that is needed to prove an inventive step over the prior art. So for example, if you have a patent that covers herbicides and you have herbicidal testing data in your patent application, and you mention in the patent application that these herbicides also have a better toxicology profile or that they also have fungicidal activity, you later on in China cannot rely on proving an inventive step other than showing that they are better herbicides than the prior art. You cannot supplement with data on better toxicology results or an additional fungicide effect that the other compounds of the prior art don't have. It's a strict limitation. Only data can be used that has been supported by initial data in the patent application. And that is also shown that there are now two standards for supplementary data submission by a draft of the judicial interpretation of the Supreme Court, which issued in June 2018, where they said for insufficient disclosure, it's good enough if the supplementary data can be deducted in general from the initial disclosure at the date of filing. So it supports something that is stated there, which is a much lower standard than that what they post for having inventive step issues where the supplementary data needs to be on an effect that is directly and unambiguously being disclosed in the specification. And to my knowledge, for most of the cases, that means the data on the effect needs to be in the application to later on use similar type of data to compare over the prior art. So it's a must to have testing data in the application. Another issue that a lot of clients have is divisional applications. There has been a practice by many practitioners to always have divisionals pending and tell clients that this is a good chance to tailor-make them to cover infringement. That doesn't work in China because no divisional from a divisional is possible if the parent case is not alive. So very important to know if you have this strategy that you need to avoid having a divisional filed which meets the criteria of unity, because then you will be stopped from filing further divisionals. The only chance that you have to file a divisional from a divisional is if the examiner finds a lack of unity. So if you want to proceed on a strategy that is based on this, you have to try to build in a lack of unity in your divisional to be allowed later on to file further divisionals on that divisional. Normally you are not able to do so, and you should advise clients that a voluntary divisional of a divisional is usually not possible. Also important is that the Patent Office follows an approach which is similar to the EPO in Europe with regards to amendments being made. There it is very important to know that it's a very strict amendment practice, which means that you almost have to have photographic identity with the amendments that you introduce in your claims. And that has also been quite important in the chemical area, where there is a case which has been handled between the PRB and an applicant, where the discussion was how to amend a Marcus claim, and there it was during invalidation, and there it was said that a Marcus claim is a single technical solution, not a set of technical solutions. And as amendments in invalidation are limited to only delete technical solutions but not amend them, Marcus claims were found to not be amendable in invalidation proceedings, which I think is a huge issue, because then you have to depend on your dependent claims, which you hopefully have and which are narrower and do not include something where the Marcus claim has been successfully attacked by someone in invalidation. So amendments both in prosecution and in invalidation undergo very strict limitations in that regard. Very interesting is also that clients often ask, we have a patent that we want to enforce very quickly because there's an infringement in the market. So they ask about expedited examination. And a lot of people refer us to the administrative measures for prioritized examination, which under point 4 says that an applicant who's ready to implement an invention, or where there is infringement occurring or likely occurring, then they can file for this prioritized examination. I think that is something which people believed would be a good solution, and it's also available for foreign applicants, which sounds good in the first place. But there's a caveat to this, and that is that this can only be used except for the case where the original patent application was first filed in China, which is not normally the case for foreign applicants. For all other cases where you use the prioritized examination, you need to have a recommendation by the relevant department of the State Council for your jurisdiction. So for domestic companies, this is not a problem. They can go to the local IPO, get a recommendation. For foreigners, it was unclear to us how we even do this. So probably they have to go to the IPO where the patent agency is located. So in our case, Beijing, to get this recommendation. Many of our clients have then given up on this and have not obtained this recommendation and have not proceeded on the prioritized examination. And if you look at statistics, it's mainly domestic companies that have thought this out. Another way to progress things is the PPH. I think there it is important to note that the most effective way is bilateral PPH, which unfortunately is not available with Australia because you don't have a bilateral agreement with China. It's mostly used by our US clients. But China doesn't have the global PPH, only the bilateral PPHs, PCT PPH and IP5 PPH, also with limitations. So for example, if you use the PCT PPH and there is any observation in box 8 of the international reports, then you will be not able to use the PCT examination way. So that's the only effective way to expedite things, but often not available to Australian clients. Also important to know about the PPH is that there are certain timelines applying, can only be done after publication of the Chinese application and before any office action has been issued. So you have to find a patent that has been granted already overseas and during this time frame, and then file for the PPH, which is also a limitation which often excludes people from using this way. Mostly it's open for US companies which use it routinely because it creates cost savings with regard to having fewer office actions and getting higher grant rates. Then another issue which I briefly want to mention is the Beijing IP Court. There are very cumbersome formality requirements. So you need to have a legalized POA, and then it's very important that the person who signs the POA has authorization to do so. That has to be given by another person, which has to have an express board decision or bylaws confirming that this person is allowed to do so. For US companies, this is a huge issue because they don't have bylaws or board decisions that might meet the criteria. So it takes a huge time to overcome these formality hurdles. And we have seen cases where appeal to the Beijing IP Court could not be filed for these formality hurdles. I think for Australian companies, it's a little bit easier if the person who's authorized is listed in a corporate register, but it requires to really check on this. So whenever you have a case in the Beijing IP Court or want to appeal there, it's very important at the most early time to address these issues because there are no time extensions available. So if you cannot get all these legalized documents ready within 3 months after preliminary filing of your case, you will be stopped for bringing a case. So it needs very early attention on those matters. Then for the last part, I will give a very fast run through enforcement matters in China. I think David mentioned once that maybe there is another webinar, go more on specific details of enforcement, but I just want to run through a few things that might be of interest for your knowledge. One is that in China, we have a bifurcated system copying the German system. That means that for every infringement action that you have filed with the courts, usually there is a co-pending invalidation case with the patent office, starting at the patent re-examination board, because usually if someone is sued for infringement, they will attack the patent. So you have two strains going on in parallel, and you have to manage this in every litigation. Usually the infringement case in the first instance is faster than the invalidation case. important to know also is for the invalidation case that after 12 months, the decision by the Patent Re-examination Board is very important because, again, reversal rates in the courts is rather low. So this decision carries a lot of weight, and that should be important to know for strategic decisions. So after finishing the invalidation part on the Re-examination Board, you have a good idea what the validity of the patent is, which might help you on the infringement side of things. What is very important to know also is that you need to have a high attention on evidence issues. No party-related material is usually deemed convincing. So all these Nobel Prize winners making statements on the inventive step are interesting for the courts and the PRB, but they carry not much weight because they think it's biased by the party bringing forward this. So what really counts is documents in the right form. So they need to be notarized if originating from China. They need to be legalized, and that is a time issue if originating from overseas. You really have to spend most of your time in preparation of a litigation chasing evidence and clarifying whether for the infringement situation you are able to prove the infringement by pure documents. There are limitations to this. For example, export activities are very difficult to cover in this scheme because you can't get notarized and legalized documents for the whole chain of infringement up to the place where the export enters another country. So that is a huge limitation. Process patents is currently also still an issue because you can't get usually access to the premises of the potential infringer, and therefore it's also difficult to enforce them with regards to documents needed. That said, I think I have to say, if you have all these documents, it's not hopeless to win patent cases in China. To the contrary, success rates are very high. So if you are good in collecting all this evidence, you have a more than 90% chance, even as a foreign company, which is not biased in any way, to win cases in China. Most of the issues come from the fact that you don't have evidence available. And what is very positive nowadays is that we also see a shift of burden of evidence that has been possible. The Beijing IP Court asked infringers to produce numbers on their infringing sales. When they didn't do so, they considered everything that the plaintiff posed as being given. So that, I think, is an interesting development which might help on evidence issues. Otherwise, you often have trouble to prove what your damage award should be because you not have access to the sales figures of the infringer. So all the main methods for damage calculation, lost profits of the patentee, infringer's gain, royalty analogy would not work if you don't have evidence on the sales figures of the infringer. So if you don't get support by the court, you have to rely on statutory damages, which are limited to 1 million RMB for very serious cases. So there you can see that you most likely will be below 200,000 Australian dollars for your maximum statutory damage award that you can get. You can also claim reasonable attorney cost, and reasonable in the past has always mean local standards. So if you have high level attorneys working on your case, you will not likely be able to recover the cost in a court action. And many people actually give up on claiming the attorney fees because the local standard is so low that they don't even make that claim. Once you win a case, I think it's also important to know that there are often issues to get the damage award enforced. So seizing money by the court often runs empty if the accounts of the infringer are empty. Then they use secondary methods like issue a bad credit to the managers of the infringing company, or do media releases, which can be helpful because they are punishment. If you have a bad credit in China, you cannot use airlines anymore or high-speed trains. So that has some effect, but it's just secondary. So what is really important is that you use mediation in court and try to get into a settlement with the other party and not try to enforce a decision. Work with the court what is possible on evidence preservation, but always be aware that there is no contempt of court type criminal actions that are really enforced. So if people are hiding, lying, it's very difficult to deal with this. So infringement actions against medium-sized companies are good because they usually attend to the injunction, which is also awarded automatically usually afterwards. But all these damage award matters are quite difficult to deal with. So focus on evidence preservation, manage the expectation of your clients. So obviously, currently there's still the statutory damage award of around 200,000 Australian dollars, which is the upper limit. Mediation in court, I would highly recommend. Be sure that you have somebody at the court who can enter into a settlement, because the settlement only becomes effective if the damage award that has been agreed on in the settlement is paid within days. And that are the cases where we have seen that were really damage awards being paid. You can also negotiate other things, so a media apology, so people see that you enforce your patents and other infringers stop their activities. So mediation and court settlement is quite a positive thing, I would say, to be used in enforcement activities. And success rate can be high if you have every evidence ready. That concludes my fast overview on China, and I would be happy to take questions from your end. Before that, I have to make the usual disclaimer that all the information is just general advice and should not be relied upon. I think we as legal practitioners know that this disclaimer has to be made, and any specific advice has to be sought out for the specific case that you're dealing with. Yeah, thank you for your attention, and hope that this overview was useful, and I'm happy to take questions now.
Yep, thanks very much, Oliver. That's fantastic. Yep, so we're going to have about 15 minutes for questions. So please type them into the chat box and we can pick them up. So while you're doing that, I'll just talk about a couple of things in there and some of my takeaway messages. Oliver mentioned the Fourth Amendments to the patent law a couple of times. There was a draft out earlier this year. The final one is expected to be out before the end of the year, but we're sort of looking for it every time the MPC Standing Committee is considering laws, and it still hasn't appeared, but we'll look for that later in the year. On the PPH policy, generally it's IP Australia's policy to push towards use of the global patent prosecution highway, rather than have a big mess of bilateral PPHs, which is why we've been going for that forum. As Oliver said, unfortunately, China is not a GPPH member, which has that gap there for us. There was a question that came in regarding PPH. My understanding is that PPH is available to an Australian company if they have a granted US patent. So they can then use that as the basis for a PPH.
That's right. If that is the case, then that's possible, yes.
Yeah. Okay, I'll kick off with a couple of questions that have come in. Firstly, can a third party make observations during a patent examination in China?
Yes, you can. You can also file them anonymously if that is of your concern. So it's possible to do so. I would usually recommend to look at which stage the prosecution is. If you do it too early, it might not be in your favor because you use all your material and you don't know what the examiner would normally do. So maybe you would anyway reject the case. So my advice is usually to await the first office action of the examiner and to see what's going on there. And also do not file them too late. So if it's already 3 or 4 office actions and it's very close to grant, there's a high likelihood that the examiner will not attend to the third party observation. So it should be filed at the right time, but it can be utilized during prosecution to use them, and can be filed anonymously, so you don't have to disclose who you are.
Yeah. Now, someone's asked about what the acceptable format is for Swiss-style claims in China and how they're interpreted by the office.
Yeah, the Swiss-type claims have to be drafted according to the old European practice, and they are the only way to overcome the issues with regard to patenting of second medical use. With regard to them, they always need to have the features in them that are relevant to the manufacturer of the pharmaceutical. So if you, for example, try to get a Swiss-type claim for dosage, I think then it's important to have limitations in that Swiss-type claim that relate to the units that have been used during manufacturing. So they have to relate to that. I think it's a very complicated discussion now to see which type of Swiss-type claims are possible or not, but usually it's the European type, and that there need to be elements in it that need to relate to the manufacturer of the pharmaceutical, which can then even cover dosage regimes, because the amount which is in the pharmaceutical is part of the process of manufacturing the pharmaceutical. But there are other types which are not accessible to this, so that is more case specific then.
Someone's asked about the use of customs for enforcement. So generally, Chinese customs, you can record, I've registered Chinese IP rights with the customs. That includes patents, it includes design patents, utility models, it can include copyright. Do you have any experience with using customs for enforcement?
Yeah, I think it's very useful for trademarks. This is a different area, but another point where it might be useful is for design patents, because it's easy for a customs officer to check on the design. It's getting very difficult for technical patents, so the utility models and the invention patents, which you can register at customs, but I've not seen positive effects from this, because the customs officer is hardly able to make a decision whether the patent is infringed or not. The only exception which I've seen people trying is that they registered the common name, for example, of a pharmaceutical with customs registrations, together with the patent, explaining that the patent covers any product that this has this common name, and then they tried to enforce this, but success is also not so high, because often the technical material of the pharmaceuticals is shipped not with the common name, so that often run empty too. So I think there's not a solution for invention patents and utility models to be really effectively used, but it's highly effective for trademarks, and a good thing to do there.
Yeah, and that's probably what you see reflected in the numbers in the recordings, that it's mostly trademarks that are being recorded there, some copyright, and then a small number of patents.
Yeah, because it is difficult to do. Yeah, some people try, and I think that's the low numbers, but it requires a lot of training to the officials at customs, which you actually can do. So you can train custom officers, but I'm still they're probably reluctant to make a technical decision on the spot there.
Now, someone's asked whether an infringement action can be brought without requesting an evaluation report. So I guess that's referring to utility models and design patents that are granted without being examined, but where you have the option to request an evaluation report from the IP office.
For the utility models, you have to submit the evaluation report. Otherwise, you are stopped from enforcing it. So it's a mandatory requirement in order to be able to enforce them. So for the invention patent, of course, that's not needed.
Someone's asked about double patenting in terms of so this is the situation you described where with a simultaneous filing for an invention patent and utility model patent, right, you can get both rights granted. Now I've asked, how does filing on the same day avoid the double patenting?
It does not avoid the double patenting. So if you file a PCT application at the same day as the utility model application, and then the utility model will be granted, and you continue with the national phase of the PCT application, and the examiner has no link between this national phase and the utility model, and the same claims would issue, then those would be invalid, both the invention patent as utility model, for double patenting reasons. So you have to be very careful if you proceed that way. That's why I recommended to file a national patent application in China together with the utility model, and then making a referral to each other in the filings, because then the examiner takes an initiative to tell you you have to withdraw your utility model if the invention patent proceeds to grant, or have to make a decision. So you will be approached by the patent office, and they prevent double patenting for you in this regard. It will not happen if you go the PCT way. So then it's your own obligation to see that the invention patent has different claims granted than the utility model, which may be a very difficult situation if they're just slightly different. So that might be a headache to decide whether it's double patenting or not, and that there are not much decisions around that.
Yeah, definitely one to get local advice on to do it all right. Another question relates to voluntary amendments during prosecution. Is it allowable to amend the claims during examination that has the effect of broadening the scope of the claims?
Yes, you can do that, but you have to consider that there's only one time that you can make voluntary amendments, which is shortly after you request for substantive examination. After that, you can only do changes or amendments of the claims with the consent of the examiner. So they have to address rejections being made by the examiner usually. And then, of course, it's very hard to go for broader claims later on. So for the voluntary amendment, initially, yes, you can. Broadening claims later on during prosecution, it's not allowed voluntary, and it might be difficult to get consent of the examiner, especially if it requires to look into examination again and then maybe do new searches. They will always refuse to such broadening of the claims. Yeah. So then the only way out would be to file a divisional.
Let me just remind people again, if you haven't done it so already, to download the handout where we've got the webinar live here. The PDF of these slides is available in the handout section. So there's another question about whether you've had experience with using patents, utility models and design patents to take down products through Chinese e-commerce platforms, through those internal IP complaint systems that the e-commerce platforms have up. And usually it would probably be trademarks or copyrights. Patents, I guess, would be a lot less common.
Yeah, you can do it. The issue there is often that you have to go through the IP complaint systems of the platforms, and that is a very cumbersome process. So I have dealt with clients with that, and they have submitted their rights, and you can actually take out things, but then new pop up. So basically, you need to hire a person that continually is following what's going on these e-commerce platforms and remove things. And some companies do that. Big electronic companies I know do this, but not everybody can do this. So for the normal person, I think it's rather important to look, how does the infringement hurt you? Is it really of a bigger volume? Try to find out all about this hurting infringement, do investigation and file a normal litigation case. Because a lot of the e-commerce offers are not actually commercially relevant. They're just offering things but not selling anything. So it's a huge effort to deal with something which has no relevance to your business. So really try to find out by your local business or from local contacts who is in the market and selling volume. And I think that's more effective to go after that.
Now, there was a further question, which I think is too technical, so I'll skip over it here. The person who asked that was about the first filing requirements. So I invite you to get in touch directly with Oliver or myself about that one. Well, that's all the questions we've got for now, so I'll just wrap up. I'm just going to go through some of my takeaway from Oliver's presentation. I think when we're thinking about patents, we always think invention patent, but we sometimes overlook the value of utility models and design patents. And that's, I think, in China, people understand the value of them, and you can see that reflected in the high filing numbers. In Oliver's stats, you could see there was more utility model patents filed last year than invention patents. People aren't doing that purely for subsidies and things. They do it because it can be a valuable right. On invention patents, of course, it's so important to get things right the first time. There's only one divisional allowed, generally, even if there's no unity issues. The amendments are somewhat restricted, and of course the supplementary data is still quite restricted. Courts usually uphold the patent office decisions, so you've got to get everything right at the patent office, at the re-examination or invalidation stage, and not try and rely on the court overturning a decision. If litigating, I think keep in mind the formal evidence requirements and other formality requirements, formality burdens that make things a little bit trickier. Certainly manage expectations on the possible damage awards and be open to court mediation for the reasons Oliver has mentioned. So that's it for our webinar. Please stay on for the survey. If you'd like to suggest potential topics or other things, you can put that in there. We read it and it informs what we do next. You can also reach out to me directly with any thoughts, suggestions or issues. And I'm sure Oliver would be happy to take questions on notes on email.
Yes, I am. Yeah, and thank you for your attendance today during your lunchtime. Yeah, I'm happy to answer questions. I think the email address is on the handout, so that's for sure possible.
Mm-hmm. Great. Okay. Thanks very much.
Thank you. Bye bye from Beijing.